Hi, this is Attorney Heather Poole. Today we're going to be talking about 245I, a special provision in the Immigration Act that allowed people who came into the United States without legal status to once upon a time get their status in the United States, to obtain their green cards despite illegal entry. Now you may ask, Heather, why are you talking about something that hasn't passed for 10 years or over 10 years? Well, 245I may still benefit you even 11 years after it expired. If someone you know had a petition filed for them, you may be able to grandfather. There are a few requirements to grandfather. If you had an employer file a labor certification application for you, an I-140, which is an immigrant visa based on employment, or a relative filed an I-130 for you, which is a family-based immigration visa petition, prior to April 30th, 2001. Let's say you've been waiting all this time for that visa number to become current, and you're still waiting, but now you're married to a U.S. citizen. You may be able to use that old priority date to stop you from having to go abroad to a consulate to get your green card interview. Now, why would this be beneficial to you? Obviously, there's pain in traveling, but also a lot of people who are here in the United States illegally don't realize that the minute they leave the United States to go to a consular interview, they're triggering the 10-year bar. The 10-year bar applies to anyone who's been in the United States for a year or more without legal status and then departs the United States. So even if you have a green card based on your spouse waiting for you at the consulate in Ciudad Juarez, you cannot get it without getting a waiver of the 10-year bar, which means you're going to be stuck outside the United States for 10 years if your waiver is not approved. This can be a significant risk for anyone to travel outside the United States. So what 245I does is it allows you to avoid having to apply for the 10-year bar waiver. If you can prove that you had a visa petition filed for you by that cutoff date, you can still use 245I on a new visa petition now, which means you would not have to leave the United States and you could interview for your green card in the United States now. Now, what if you didn't have anything filed for you? Maybe a relative, such as your mom or your dad, had something filed for them. You may be able to qualify as a derivative beneficiary of their petition, depending on what your age was at the time. I suggest you talk to an immigration lawyer about your history and know your parents' history when you're talking to an immigration lawyer, and maybe 245I can save you a lot of pain and trouble. If you would like my help with your case, feel free to give us a call.